Counsel, before you sit down, may I ask you another question?
Yes, by all means.
I'm really trying to figure out how you're teeing this up. And is it, are you saying that the attorney, Ms. Clark, is able to assist her in her defense in this disciplinary proceeding?
Absolutely.
So that if there's any concern about protection of clients, it's got to be done under the envelope of her proceeding under this disciplinary proceeding as opposed to a tangent placement on disability inactive status.
That's correct.
Okay, I just wanted...
Yes, this is with regard only to Ms. Clark and whether or not if there's a Rule 28 disability with regard to her disciplinary case. That's all this is about. It's a very limited issue, and it's very focused.
And it's your position that there was no assertion of a disability at the time of the, I think it's the, I can't remember now whether it was June or July, but the 25th of that hearing.
Well, she was in the hospital.
Well, but that's not my question.
And that's not necessarily a disability, though, that limits her from participating in her defense. And those words never came out of my mouth. And I was there, and I can tell you that I did not say, at least from what I recall, that she was unable to assist in her defense.
Let me ask you this. At least as I understand some of the submissions, is that there's been a request for reasonable accommodation?
That's correct, Your Honor.
And I assume that's a reasonable accommodation for some disability?
But it's not a disability that infringes upon her ability to participate in her defense. You see, there's a difference. I have a disability. I have rheumatoid juvenile arthritis. But I am able to defend clients. I'm able to assist Ms. Clark in her defense. If something like this were to happen to me, I would be able to assist in my defense, even though I have a disability of juvenile rheumatoid arthritis. That is not something under Rule 28.
What is her disability exactly?
Well, Ms. Clark would be better able to answer that question, because I am not a medical professional, and I certainly can't tell you that. I'm sorry.
Counsel, I'm trying to nail down more specific here. At the point in time that the request for accommodation was made, was the request for accommodation being, is it delay the proceedings till I get out of the hospital? Was it any more than that?
That was my intention, and what I recall was the conversation at that date was that the referee indicated that he had a murder trial coming up, that he wouldn't be able to delay the proceedings because he had a murder trial coming up, and that he was under the impression that he had a date certain by which he had to conclude this case, and that he would not be able to conclude this case if it was continued out because he had a murder trial. And I'm sure the transcript will bear that out.
Counsel, we also had an assertion, as I understand it, that your client had been locked out of her email account so that she couldn't represent clients.
And I'm not a party to that, sir. I don't know. I mean...
Well, but isn't that a factor that we have to take into consideration?
It's my understanding that that the law firm, which is separate from Jill Clark, the attorney, that the law firm was taking steps to figure out how to accommodate the needs of the various clients of that law firm, and was in the process of lining up some attorneys to take various cases and to keep them rolling along. So that's my understanding of what the law firm was doing. And I do know that from my information that, you know, Ms. Clark's husband initially was doing some of that, trying to cover the bases, but then they got another office person, manager, to take some of that over, is my understanding. So that, again, that's distinct from the law firm versus the attorney.
But isn't that all indicative of a disability? Is it at least not evidence that would be probative of a disability that would render your client unable to participate in her defense?
No, I think that for a disability, you need to have hard medical evidence. You could claim anybody is disabled just on allegations. That you need to have medical evidence that you can point to, because if you do not have established medical criteria for what that disability is based on, in the end, when you get down that road, how is that attorney ever going to be able to address that issue and say, well, now this was what the disability was?
So can the director compel? Can the director compel an attorney to undergo the necessary testing to ensure that a disability does not exist in the face of some evidence, perhaps prima facie evidence, that such disability does exist?
Well, you know, that's an interesting question. If you look under Rule 28 here, it says under 28B, it says that immediate transfer, that the court may immediately transfer a lawyer to disability inactive status upon proof that the lawyer has been found in a judicial proceeding. There has been no such judicial proceeding. Now, I do not see anywhere within this Rule 28 where it says that the board has the ability to do that.
Well, as I understand it, the board wasn't seeking to do that. This is the recommendation of the referee.
That's exactly right.
Based on what was in front of the referee.
That's because he did not think that he could continue the proceedings. And the transcript, I'm sure, of that June appearance will bear that out. Because that was part of the quandary. What do we do if we're not going to proceed today? What is the vehicle by which we can continue this on? And he didn't feel that he had the authority to just simply continue it or the timing to be able to do a continuance because he had this murder trial. And he had to coordinate them, and he felt he was under a mandate by this court to have it done by a date certain. So that's why we're here. I never brought up Rule 28 that day. And we do not assert a disability under Rule 28.
Counsel, maybe this question is more appropriately directed at the attorney, but if you're saying that there is no continuing assertion of disability, and we were saying, okay, go ahead tomorrow, deal with the disciplinary proceeding, are you ready to proceed?
With reasonable accommodations. And see, this is what we have put in our memorandum, is that just as in any profession, any workplace, there is a need occasionally for reasonable accommodations. And as I indicated in our memorandum, that may simply be that there be more frequent breaks, that may be, maybe half day at a time because of fatigue issues. Okay, well, that could happen. If the court would feel more comfortable that in order to determine what those reasonable accommodations are, maybe that's the issue that the referee should hear testimony on, simply because then everybody knows that the reasonable accommodations are coming from a medical standpoint, that they're not just something arbitrary that has just come from either side, but it's something that is actually medically recommended, that everybody can point to and say, okay, we have a basis for what those reasonable accommodations should be in this type of case. In this type of case. It wouldn't be for all cases, obviously.
Counsel, it strikes me as a little odd that the referee makes his recommendations based on